Okay, stop scrolling. Right now, the Department of Justice has quietly done something that could remake how magazines are regulated in this country. In a filing tied to a Washington, D.C. prosecution, the government effectively admitted that broad bans on magazines over 10 rounds don't square with the Second Amendment, and they've asked a court to vacate the conviction at the center of the case. That's not lawyering around the edges. That's the federal government stepping back and saying a statute it once defended can't stand. If you own magazines, follow firearms law, or care about constitutional precedent. This is a live story that matters. I'll walk you through why this flip matters, who it helps, and what to watch next. But first, the short version. This is a federal about-face that could ripple through cases and state laws across America. So let's back it up. The case that sparked all this is United States versus Benson. Who's Benson? A D.C. resident who got caught with a standard capacity magazine, the kind most of us would consider factory normal on a duty pistol. Prosecutors went after him under a D.C. law that capped magazines at 10 rounds, treating it as a criminal violation. He fought back, arguing that the restriction itself was unconstitutional under the Second Amendment. Now, here's the kicker. That challenge wasn't just a throwaway defense, it pulled in real precedent. Think back to the Supreme Court's Heller decision right here in the district, which recognized handguns as in common use. Benson's legal team basically said, look, if a Glock off the shelf ships with a 15-round mag, how is that not common use? The trial court had initially gone forward, but on appeal, DOJ shocked everyone by flipping sides. They agreed the D.C. ban couldn't be squared with Heller, and they joined in asking to wipe Benson's conviction. That's like the referee walking over mid-game and saying, yeah, the rulebook we used earlier doesn't actually apply. And make no mistake, that single concession is what sent shockwaves through the firearms community and the legal world. Here's where the story flips the script. The Department of Justice didn't just file a bland memo. They basically told the appeals court that enforcing a blanket ban on so-called large-capacity magazines is unconstitutional. That's the federal government, the same folks who used to argue in favor of restrictions, now admitting the law won't survive the Supreme Court's test. Think about that. For years, we've seen the DOJ defend bans by leaning on public safety arguments. Now, they're aligning with the logic that a 10-round cutoff is arbitrary and out of step with the Second Amendment. This isn't just about one D.C. resident. It's a direct acknowledgement that Heller and Bruen reshaped the ground rules. What makes this unique is that it's not a think tank statement or a politician's tweet. It's the official legal stance of the federal government, written into a case filing. When prosecutors themselves ask to vacate a conviction, they're signaling to judges, defense attorneys, and future defendants. The government no longer sees that law as enforceable. In plain English, that means the next time a case comes up in California, New Jersey, or Illinois, defense teams will point to this filing and say, even DOJ admits these bans don't hold. And while courts aren't bound to follow DOJ's lead, it's a powerful marker that the tide has shifted. For folks who've been paying attention, this is the kind of legal pivot we rarely see in firearms law. Anytime you talk about guns and the Constitution, you can't skip the Supreme Court. Two landmark cases hang over everything here: District of Columbia versus Heller and New York State Rifle and Pistol Association versus Bruen. Start with Heller back in 2008. The court made it crystal clear that firearms in common use are protected under the Second Amendment. That's the reason you can't just ban every handgun, because millions of Americans rely on them for defense. Now plug that logic into magazines. If 15-round Glock mags or 30-round AR mags are what most rifles and pistols ship with, it's hard to argue they're anything but common use. Fast forward to Bruen in 2022. That case raised the bar even higher. The court said if the government wants to restrict a firearm, accessory, or practice, it has to prove there's a historical tradition of that restriction in American law. Show us an example from the 1700s or 1800s, or you don't get to regulate. And spoiler alert, there's no tradition of 10-round magazine caps in the founding era. Put those two rulings together, and you see why DOJ had to pivot. They couldn't point to a historical ban on common magazines, and they couldn't deny that millions of Americans use them every day. Even the dangerous and unusual exception doesn't fit, because there's nothing unusual about a factory-standard 30-round AR mag. That's why the government stepping back here isn't just tactical. It's practically admitting the Supreme Court has already boxed them in. Now, here's where it gets real for the broader firearms community. A DOJ concession in one case doesn't just stay in one courtroom. Defense attorneys across the country are already circling this like sharks. Picture a judge in California hearing a magazine case, and the defense lawyer drops a copy of this DC filing on the bench. The argument is simple. If the federal government won't defend a 10-round cap, why should the state? We've already seen waves of litigation in New Jersey, California, and Illinois over so-called large-capacity magazine bans. Most of those cases were grinding through the appeals process, waiting for the Supreme Court to weigh in again. Now, those plaintiffs just got fresh ammo, figuratively and literally. They can say, "Your Honor, even the DOJ agrees this law is unconstitutional." That doesn't guarantee a win, but it stacks the deck. On the industry side, manufacturers and distributors are watching closely. If courts start toppling these bans one by one, it reopens entire markets. Think about how many states restrict magazine sales to 10 rounds. If those caps fall, overnight you've got a surge in legal demand for standard capacity magazines. And when demand spikes, the supply chain follows, which means price shifts, availability changes, and more options back on the civilian market. There's also the legal strategy angle. Gun rights groups now have a blueprint. File challenges, cite Heller, cite Bruen, and then tack on this DOJ flip as Exhibit A. For judges who were on the fence, seeing the government switch sides might be the push that tips the scales. Bottom line, this isn't just about Benson in D.C. This has the potential to cascade into dozens of active cases, unsettle state laws, and force the Supreme Court to step in sooner rather than later. So, what does this actually mean if you're just a gun owner trying to stay on the right side of the law? First off, if you're living in a state with a 10-round cap, don't toss your magazines or rush out thinking the law disappeared overnight. The local statutes are still on the books until courts strike them down. But what changed is the leverage. Defense attorneys now have a powerful argument that prosecutors can't easily brush aside. For people already facing charges, this DOJ shift is like a lifeline. Imagine being Benson, sitting there convicted over a 15-round mag that came stock with your pistol. Overnight, the same government that put you on trial admits the law doesn't stand up constitutionally. That opens the door to vacated convictions, reduced sentences, or cases being dropped entirely. Then there's the question of old convictions. Could past defendants come back and challenge? In theory, yes. Lawyers will file motions to revisit those cases, citing this reversal. Whether courts grant relief will vary, but don't be surprised to see headlines about convictions being wiped out. For everyday owners, the practical impact is confidence. It signals that if you end up entangled in one of these cases, you're not fighting alone. The government isn't standing unified against you anymore. Part of it is standing with you. That's a major shift in the balance of power. But let's be clear, this doesn't mean you should test the law just to make a point. Until the courts officially strike these bans, local authorities can still arrest and charge. Think of it like a crack forming in the dam. The water hasn't burst through yet, but you can see where it's going. When you talk to attorneys who live and breathe Second Amendment litigation, they'll tell you this move opens 3 clear paths. Scenario 1, narrow win for owners. Courts could decide that magazine bans over 10 rounds don't pass constitutional muster and strike them down piece by piece. That would free up standard capacity mags in some states, but still leave room for governments to argue around the edges. Think carve-outs for sensitive places, or special categories. That's a partial victory, but not the final word. Scenario 2, broad collapse of magazine bans nationwide. If one circuit court rules against these laws and the Supreme Court takes the case, we could be looking at a sweeping decision that invalidates every 10-round cap from coast to coast. That's the nuclear option for anti-gun states, and it's exactly what groups like FPC and GOA are pushing for. It would also send a message that Bruen wasn't just about carry permits. It's about every modern attempt to sidestep the Second Amendment. Scenario 3, the slow grind. Courts drag their feet, different circuits rule different ways, and we end up with a patchwork where one state respects common-use mags and the next state jails you for the same gear. That uncertainty drives lawsuits, splits families who move for freedom, and forces the Supreme Court's hand eventually. Now, which way it breaks depends on judges, timing, and how aggressively defense attorneys press this new DOJ position. But the takeaway is simple. The ground has shifted. For the first time in decades, the federal government isn't anchoring the anti-magazine side of the fight. So here's the part that matters if you're watching this from your living room with a gun safe in the next room. Number 1. Don't assume the law is gone until a judge says it's gone. Keep following your state's magazine rules, even if they look shaky right now. Number 2. Paper trails protect you. If you own standard capacity mags, hold on to your receipts, transfer papers, and any documentation that shows how you obtained them. Courts move slowly, but records can save you if questions come up later. Number 3. Plug into your local legal community. Join a gun rights group, stay current with updates, and don't rely on headlines alone. When the DOJ changes course, it's huge, but it doesn't instantly rewrite 50 state codes. Groups on the ground often know when cases are about to break. Number 4. Be smart on the range and on social media. Don't post videos bragging about ignoring the law. That's the kind of thing prosecutors screenshot. Train, practice, and document responsibly, but stay low-key until the dust settles. And finally, remember this is not legal advice. I'm not your lawyer. I'm just the guy giving you a straight read from the gun bench. If you're in a bind, talk to an actual attorney who understands firearms law. Now, if you're wondering how we're going to bring this story off the page and onto the channel, here's the plan. Later this week, I'll roll in some actual courtroom filings on screen, not the dry legal stuff, but the key pages where DOJ admits the ban won't stand. That way, you can see it in black and white, not just hear me talk about it. I'm also lining up a visual breakdown of magazine capacity bans across states. Picture a U.S. map with color codes: green where standard capacity is legal, red where it's capped, yellow where lawsuits are pending. That's the big picture you don't get from headlines alone. To make it more real, I'm working on a quick sit-down with a firearms attorney who's been tracking these cases. Hearing a lawyer explain what this reversal means for everyday gun owners will hit harder than any blog post. And if scheduling allows, we'll throw in a range demo, showing factory-standard mags running as intended, side by side with neutered 10-rounders. Trust me, you'll see the difference in reliability and reloads. That's the content I want you to have. Not speculation, but actual documents, expert voices, and hands-on demonstrations that connect the dots. That's it for now, folks. The DOJ's reversal on magazine bans is a big shift, and it's one we'll keep watching closely. What do you think? Is this the crack in the wall, or just a one-off case? Let me know. Make sure you like, subscribe, and drop a comment down below. Stay sharp.